Hello, classmates and Professor Garner. Rick Hodge here, coming at you with this week's 7.1 graded assignment. And I decided to do the case study of Franklin versus Gwinnett County Public Schools. And in this case, Christina Franklin filed a complaint in December of 1988 in district court of continued sexual harassment from Andrew Hill. And Hill was a teacher and coach in the district, and Franklin was a student at the time, and it happened over multiple years that she was a student at the high school. And with this case, teachers, administrators, she claimed, knew about what was going on, knew about what was taking place, and didn't do anything to stop it and allowed it to continue to happen. They also discouraged her from pressing charges against Coach Hill and basically tried to persuade her in any way they possibly could not to tell on him or get him into any type of trouble. Before that, in April of 1988, Hill resigned on the condition that all the charges against him be dropped. And the school then at that time just closed the investigation and didn't do anything with it. The case discussed this case discussed the influence that Title IX has on a school district. And the reason for that is because Franklin sued the school district for damages under Title IX legislation. She sued, stating that nobody should be subjected to discrimination in education that is receiving money from the federal government. Those are basically the facts with the case. As we move on with arguments for both sides, first of all, just a quick reminder, when looking at the case, this does not deal with the case that went against Coach Hill and any penalties that need to be taken against him. This is simply against the school district themselves and how much they are liable for throughout this process. That's what I had to keep reminding myself, because you keep talking about a teacher and coach that was sexually harassing or with a student. Obviously, there's going to be a lot of problems in today's world, losing your job, arrested, those types of things. But this case dealt more with is the school district liable, and how much is the school district accountable for protecting the students and working with them. So Franklin states the school district knew it was going on and didn't do anything about it. The school district claims that the suit should be against Hill, and that's what you need to be going after, not the school district. The school district had nothing to do with it. Franklin sued with the basis of Title IX, and a school district being a government entity that it is receiving federal money, then they are definitely liable for the employee, Mr. Hill, Coach Hill, that he was what he was doing was wrong, and she sued them for that. The school district countered that that cannot be claimed under Title IX. This is kind of where the case got a little bit difficult to follow, because it went into a lot of the legal ramifications of everything. And in my reading, it kind of got difficult at times. But I'll try and give it a whirl here. District court dismissed the complaint first because Title IX does not authorize an award of damages, and then the Court of Appeals affirmed that when they were done. However, this conflicted with another decision of the case of the Court of Appeals, and they eventually reversed and eventually granted her a win and through the legal battle. But when legal rights are invaded and a federal statute provides for a general right to sue for such invasion, federal courts may use any available remedy to make good the wrong that was done. And that's kind of what they decided was best. It was ruled an award would violate separation of powers, because it would expand the federal court's power reserved for executive and legislative branches, and they didn't want to separate those two different types of branches. Application of the traditional rule in the case requires the state entities to pay monetary awards out of the treasuries for intentional violations of federal statutes. It was later ruled that back pay does nothing. It was first ruled that back pay does nothing for the petitioner, because Hill no longer teaches at the school, and she was no longer a student in the school system. However, the Supreme Court, when they got involved and it went up to the Supreme Court, they reversed it, and monetary damages are available and they are limited to back pay. Ruling made school district responsible under Title IX, and decision stated compensation can be awarded in sexual harassment cases. And that's what the Supreme Court ended up ruling on, and then eventually ruled in her favor, again, after the District Court and Court of Appeals ruled that she cannot. Again, kind of a difficult case to follow, and with some of the legal terminology that was used, but that's kind of the best I could do in coming up with that. But what this means for athletic directors, well, first and foremost, the obvious, which is an administrator should know all of the sexual harassment claims. Any claim needs to be handled quickly. Again, this was back in 1988, and they kind of drug their feet on it. They tried covering things up. They tried protecting the teacher / coach, and they tried protecting all of that. Everything came out into the open anyway. As she said, everybody knew everything about it. So as an administrator, it's very difficult to cover this stuff up, especially with social media today, because kids talk, then their parents get involved. Things are on social media. I know this was back in 1988, but with today, it's very difficult to cover this stuff up. And as an athletic administrator, you're going to have to work very quickly, and you also have to do the right thing. When you handle a situation like this, it needs to be done appropriately, and not cover up. And that can be difficult for an administrator, because a lot of times those are your friends. Because if you are a coach, and then you become an athletic director, chances are the coaches that are around you are kind of your friends. And it's difficult to work with if these are allegations against one of your friends. But again, you have to do the right thing, because your job will be on the line as well as this person's if it's not handled correctly, and then lawsuits can be made. This is especially true with allegations from a student. In this case, it was about a student. And if that student's a minor, much like as if it were like child abuse or something like that, it has to be reported quickly. And you have to do a thorough professional job with that, kind of with what you're doing. But the other thing, too, is sexual harassment against, for a coach, maybe possibly against another coworker. Female coworker, male coworker, whatever, telling inappropriate jokes, making inappropriate statements to them, things like that. I think as an athletic director, you could be around and hear. And kind of what I talked about before was, if you do hear something like this as a leader of the athletic department, you might want to pull that coach aside, and let them know that's not acceptable. When you make comments like that, somebody can take it the wrong way. They might not find the humor in it, and now they are filing a grievance against you for sexual harassment or something like that. So as a leader of the athletic department, it's important that you look to do some different scenarios like that. So it was a good case. I recommend you read through it, because it does deal with some sexual harassment issues, but it was kind of difficult for me to follow at times, but I enjoyed it. So thanks a lot for listening to my report on the graded assignment. Take care.